All right, everybody. Well, in this lesson, we're going to just go through chapter four discussion questions. There's only, I think, eight of them, so it shouldn't take us too long. And I think they're pretty straightforward. So hopefully, this will be more of a review after you read the chapter. Let's get ahead and get started. All right, question number one. Let's define the probate process. Well, first of all, we need to know that it's a legal proceeding, really, that serves to provide the validity of an existing will, to provide the distribution and distribution of a living will and prove its validity. Okay. A couple of things that it does is it looks to have an orderly distribution of assets. It also makes sure that debts get paid, and it provides a legal title to heirs and legatees for the property that they inherit. Okay, so that's pretty much what the probate process does. All right, question number two. Describe at least three advantages and three disadvantages of the probate process. So if we have advantages on this side and disadvantages, I could spell. Yeah, let's just start over. All right. Number one, on the advantages side, it can protect creditors. It provides a clean title for those that receive property. It allows opportunities for various we'll say various mm, people to be heard. And this is a public hearing, and it provides orderly distribution of assets. Okay. So, what are some of the disadvantages? Well, there's a cost associated with it, so it can become costly. It can also provide delays in the distribution, and as I previously mentioned, it is open to the public. So, public scrutiny and just public information being available. Okay. Number three, identify alternatives to probate regarding the disposition of property. So just keep in mind that there's different ways that assets can move from owner to beneficiary that does not require to go through probate. Um, so we have anything that's held with uh, joint with rights of survivorship titling, tenants by the entirety would be another one. If we own, so this is one, uh, trust property, because the trust is owned it, and that would be both a revocable and irrevocable trust. If property passes through an insurance policy, And that could be an annuity or a life insurance contracts. So we'll put life insurance and annuity. Now, keep in mind that obviously life insurance, there may be an exception there in that if the beneficiary that has been designated has predeceased the owner, um, that could come back, those assets could come back into probate. So just keep that in mind. And then there's also we have payable on death and transfer on death. Okay. Um, and I think there's actually another slide that is going to talk about breaking those apart. Let's just make sure I'm not missing. Yeah. So we'll just discuss that here in a moment. Okay. Question four. Discuss the main differences between an executor and an administrator. And this is pretty straightforward. The decedent chooses an executor, and the court chooses an administrator. So basically, the difference and there is who selects them. Um, and in the administrator, typically, let's go here, must post a bond. And that requirement, of course, can be waived for the executor because, again, this is the decedent has actually identified this individual. All right, number five. It says to list the duties of the executor and the administrator. So, on this one, I'm going to just go through both, and then I will look at some differences. Okay. So, both must locate the property owned by the cedent. Okay. They both must safeguard the property. They need to identify, any type of creditors or parties interested in the assets. So, notify. And typically that's through, ads or interested parties. They must pay the expenses to the court. They must pay the debts. They need to file tax returns. And of course, they're going to distribute assets. Okay. Mhm. All right. The executor and the administrator. Okay. The executor is going to locate and proves the will. They're going to locate witnesses, and they are going to receive letters of testamentary from the court. The administrator petitions the court. For the appointment. So if it is a court appointed, then someone will go and say, "I'm would like to be the administrator." They receive letters of administration, and they also will post bond, like a surety bond. Right. So again, they're primarily doing the same thing. There's just a few differences in how they begin their process. But from the time that they are enacted in that role, their requirements pretty much are the same. Okay. So define payable on death or transfer on death. Okay. Um, Pretty straightforward. Both of these are contracts. Okay. And because they're contracts, they're going to allow the owner these assets to bypass probate, and it lists beneficiaries for those assets to be transferred. Okay. And then I guess really the only kind of significant thing is that payable on death is usually associated with bank accounts. Transfer on death is usually associated with investment accounts. Now, because they kind of mean the same thing, if you were to go to your call your broker at Charles Schwab or whatever and say, "Hey, I would like to put a payable on death," they know what you mean, and so whatever term they use, payable on death or transfer on death, they mean the same thing. So I don't think it's a super significant differentiation. All right, question number 7. Identify assets that pass outside of probate by contract law. And we've already gone through some of this in some of these other questions, but let's just kind of list several of these. So hopefully we remember that life insurance, again, traditionally beneficial owners that are still alive would pass. Qualified retirement plans, you typically will list a beneficiary on those assets. Individual retirement accounts and annuities also will have contracts. We have POD, payable on death plus transfer on death. Okay, so those are basically the main ways, or the assets. Anytime an asset is either titled, so this is a titling. Um, well, I guess there's also a contract. All of these are contract focused. Okay, and they're going to pass by through contract. All right. And I think this is the last question. So identify assets that pass outside of probate by titling or trust law. Okay, so here we're titling or trust law. So title would be like joint with rights of survivorship. We would have tenancy by the entirety. And on the trust is really going to be all trust accounts, whether it's a revocable trust, an irrevocable trust, etc. All trust accounts will pass by outside of probate. All right, everybody. Well, and that wraps up chapter 4 discussion questions.